Hello students, we'll start with the third chapter under the business law, that is pre-consent, lawful object and contingent contract. Okay, under that first topic is free consent. Okay, we'll see what do you mean by free consent. Okay, first we'll see the what do you mean by consent. Okay, see, in a contract the parties involved in it should give their consent, right? The parties involved in the particular contract, they should give their consent, or consent is something with their opinion, right? The consent of the party means that there should be a perfect meeting of minds of the both the parties. There should be perfect meeting of the minds. There should be any room for confusion or misunderstanding between the parties regarding the subject matter or any other terms of the contract. There should not be any misunderstanding between the terms and conditions of the contract. Both the parties must be aware of all the terms and conditions of the contract. Besides understanding each other, they should understanding the each other, they should understanding the each and every the terms and conditions of the contract. This is the consent, right? It is their duty to get necessary information required for the performance of the contract. Otherwise, the contract becomes the void. They should know each other and each and all condition, the principles or the each and rules and regulations. If they're unknown about any things, that particular contract becomes the void. Next, we'll see the what. Then, what do you mean by pre? It's nothing but free consent, right? Okay. For the enforceability of an agreement, it is not only necessary that the parties to the agreement should give their consent, but their consent should also be free. Okay, the consent is very necessary. Only the consent is not enough, but the consent should be free consent, since free consent is an essential element in the information of the contract. Free consent is the consent which is obtained by the free will of the parties, and neither the party should have been forced or induced to give his consent. It's nothing but free consent is obtained by the free will of the parties. They should, in their own willless, they have to agree for the particular contract, and they should not be forced by any other person, and should not be induced to give his consent. Okay, this is what the free consent means. They have to agree to enter into a contract with the will of themselves. Okay, should not by force or any other by threatening, or threatening is not threat is nothing but ಬೆದರಿಕೆಯಿಂದ ಅವ್ರು ಎಂಟರ್ ಆಗೋದಲ್ಲ, ಅವರ ಓನ್ ವಿಶ್ಯಿಂದ ಎಂಟರ್ ಆದರೆ ಆಗಬೇಕು ಯಾವುದೇ ಕಾಂಟ್ರಾಕ್ಟ್ಗೆ. ಅದನ್ನು ನಾವೇನು ಹೇಳ್ತೇವೆ, ಪ್ರೀ ಕನ್ಸೆಂಟ್ ಅಂತ ಹೇಳ್ತೇವೆ. ಓಕೆ, ಬಟ್ free consent is the consent which is given by the free will of the parties of their own accord. Next, we'll see, according to section 14 of the Indian Contract Act, consent is said to be free when it is not caused by. The consent is said to be free, okay, when it is not caused by. Okay, when it is not caused by the five things, then we can say that the consent is free. ಈ 5 ಅಂಶಗಳು ಇಲ್ಲದಿದ್ದರೆ ಯಾವುದೇ ಒಂದು ಕನ್ಸೆಂಟಲ್ಲಿ ನಾವು ಅದನ್ನು ಫ್ರೀ ಕನ್ಸೆಂಟ್ ಅಂತ ಹೇಳ್ಬೋದು. 5 ಥಿಂಗ್ಸ್ ಆರ್ ದೇರ್. ಫಸ್ಟ್ ಒನ್ ಇಸ್ ದ ಕೋಯರ್ಷನ್, ಸೆಕೆಂಡ್ ಒನ್ ಇಸ್ ದಿ ಅನ್ಡ್ಯೂ ಇನ್ಫ್ಲೂಯೆನ್ಸ್, ಥರ್ಡ್ ಒನ್ ಇಸ್ ದಿ ಫ್ರಾಡ್, fourth one is the misrepresentation, and fifth one is the mistake. Okay, first one is the free consent. There should be a free consent, and we can say that consent is free when it is not caused by the following things ಇಲ್ಲದಿದ್ದರೆ ಮಾತ್ರ ನಾವು ಅದನ್ನು ಫ್ರೀ ಕನ್ಸೆಂಟ್ ಅಂತ ಹೇಳ್ಬೋದು. ನಾವು ವಿಲ್ ಸಿ ಒನ್ ಬೈ ಒನ್ in detail. Okay, first one, see coercion. What do you mean by coercion? The term coercion implies compelling a person to enter into a contract. In such a cases, the consent of the party is obtained by the use of force or under a threat. Forcefully, a person is enter into a contract, or because of the threatening another person, he is going to enter into a contract forcefully or by threatening. ಫೋರ್ಸ್ ಮಾಡಿ, ಅದರ್ವೈಸ್ ಥ್ರೆಟನ್ ಇಸ್ ನಥಿಂಗ್, ಬೆದರಿಕೆ ಹಾಕಿ ಇನ್ನೊಬ್ಬರನ್ನು ಕಾಂಟ್ರಾಕ್ಟ್ಗೆ ಎಂಟರ್ ಆಗುವ ಹಾಗೆ ಮಾಡಿದರೆ ಅದನ್ನು ನಾವು ಕೋಯೆಷನ್ ಅಂತ ಹೇಳ್ತೇವೆ. ಓಕೆ, Section 15 of the Indian Contract Act defines coercion as the committing or threatening to commit any act forbidden by Indian Penal Code. ಕಮಿಟಿಂಗ್ ಆರ್ ಥ್ರೆಟನಿಂಗ್ ಟು ಕಮಿಟ್, ಮಾಡದಿದ್ದರೆ ನಾನು ಹೀಗೆ ಮಾಡ್ತೇನೆ ಅಂತೇಳಿ, ವಿ ಆರ್ ಥ್ರೆಟನಿಂಗ್ ಟು ಕಮಿಟ್ ಎನಿ ಆ್ಯಕ್ಟ್ ವಿಚ್ ಈಸ್ ಫರ್ಬಿಡನ್ ಬೈ ಲಾ, ವಿಚ್ ಈಸ್ ಅಪೋಸಿಟ್ ಟು law or Indian Penal Code, or the unlawful detaining or threatening to detain any property, detaining or unlawful detaining the person or any property to the prejudice of any person, whatever with the intention of causing any person to enter into an agreement. Okay, it's nothing but forcibly enter into a contract, or the threatening a person to enter into a contract which is against to the Indian Penal Code. Okay, committing any act or threatening to commit any act which are against the Indian Penal Code. Next to see essential elements of coercion. Coercion, what are the main essential elements of the coercion? See, coercion includes threat, physical compulsion, and menace is nothing but injury to the property. Coercion mainly includes physical threat. Threat is nothing but ಬೆದರಿಕೆ. Physical compulsion means physically injure. Physical compulsion is nothing but physically doing injury to a particular person, right? Or injury to the property, or injury to physical injury, or physical injury to a property. For a injury to the person or injury to the property, and the threat, these things included in the coercion. Then to constitute coercion, there must be a clear utterance of threat or commission of act. To constitute coercion means there should be a utterance of threat, there should be a threat, or there should be a commission of an act. There should be a threat, or there should be an injury to the person or injury to the property. Okay, without the threat, without the injury to the person or property, we cannot say it is a coercion. Next, the threat or act constituting coercion must amount to an offense punishable under the Indian Penal Code. The particular threat or the particular act, okay, which should be punishable under the Indian Penal Code. The coercion must amount to an offense. It should be an offense. Coercion is something, it should be offense which is punishable under the Indian Penal Code. Next one, the act amounting to coercion. The act amounting to coercion must be committed with the intention of causing any person to give his consent to the agreement. The act is nothing but injury to the person or injury to the property of a person. The act coming to coercion must be committed with the intention of what? Causing any person to give his consent to the agreement. The causing another person for the intention of by taking his consent to the agreement. ಇನ್ನೊಬ್ಬ ಪರ್ಸನ್ಗೆ ಅರ್ನ್ ಮಾಡೋದು ಯಾವ ಇಂಟೆನ್ಷನ್ ಇರಬೇಕು, ಅವನನ್ನು ಅಗ್ರಿಮೆಂಟ್ಗೆ ಕಾಂಟ್ರಾಕ್ಟ್ಗೆ ಎಂಟರ್ ಮಾಡುವ ಹಾಗೆ ಮಾಡುವುದನ್ನು ಮಾತ್ರ ನಾವು ಕೋಯೇಷನ್ ಅಂತ ಹೇಳ್ತೇವೆ. ಓಕೆ, ದ ಆಕ್ಟ್ ಅಮೌಂಟಿಂಗ್ ಕೋಯೇಷನ್ ಮಸ್ಟ್ ಬಿ ಕಮಿಟೆಡ್ ವಿತ್ ದ ಇಂಟೆನ್ಷನ್ ಆಫ್ ಕಾಸಿಂಗ್ ಎನಿ ಪರ್ಸನ್ to give his consent to the agreement. Okay, next one, it is not necessary that the act amounting to coercion must be committed by a party to the contract. It may be proceed from any party, even from a stranger to the contract. This is the main. See, it is not necessary that the act amounting to coercion must be committing by a party to the contract. The act commit, for example, a person is going to beat another person. Okay, A is going to beat B person. The person A, it's not necessary to he is a party to a contract, it's maybe a third party. Okay, so amounting to coercion must be committed by a party to a contract. It may proceed from any party, even from a stranger to the contract. The person who is doing the injury to the person, or injury to the property of the person, that person is maybe the party of the contract and may not be the party of the contract. It's not necessary to be the party of the contract. He may be the stranger or third party to the contract. Okay, next one, it is not necessary that the threat or act amounting to coercion must be directed against the other contracting party. It may be directed against any person, even against a third person. It's the opposite. The person who is doing the injury, that person, okay, who is making the injury, right, particular person, he may be or may not be the party to the contract. Under the same thing, it is not necessary that threat or act amounting to coercion must be directed against the other contracting party. It's not necessary to making the injury to the contracting party. Okay, it may be making injury to the other person's son, other person's wife, right? it may be directed against any person, even against a third party. We can make the injury to the directly to the contracting party and his property, or we can make injury to the person, the other person, third persons also, maybe the son or a friend or the wife of the contracting party, or the property of the wife. We can make injury to other persons also. Next one, it is not necessary that the coercion must be committed in a place where the Indian Penal Code is in force. In other words, it is immaterial whether the Indian Penal Code is or is not in force in the place where the coercion is employed. Okay, if the coercion is employed in the out of the country, it's also called as the coercion. It's not necessary that the coercion must be committed in a place where the Indian Penal Code is in force. Where in other words, it is immaterial whether the Indian Penal Code is or is not in the force in the place where the coercion is employed. Okay, it's not necessary to the particular act is committed where the Indian Penal Code is in force. It may commit outside India, or the place where the Indian Penal Code is not in a force also. Okay, these are the main essentials or main things about the coercion. Next, we'll see some examples of the coercion. First one, after giving a good beating to B, A makes B to agree to sign a promissory note. Now A is beating B. Okay, A is the person who is beating the B. So after giving a good beating to B, A makes B to A make after giving good beats to B. A is giving beating. A is beating the B, and A makes B to agree for to sign the promissory note of rupees 1000 in his favor. A is beating B. ಸರಿ ಹೊಡೆದ ನಂತರ ನೀವು ಸೈನ್ ಹಾಕು ಪ್ರಾಮಿಸರಿ ನೋಟಿಗೆ ಅಂತೇಳಿ ಬಿಗೆ ಫೋರ್ಸ್ ಮಾಡುವಂಥದ್ದು, ಅದನ್ನು ಕೋಯೆಷನ್ ಅಂತ ಹೇಳ್ತೇವೆ ನಾವು. ಓಕೆ, here the agreement between A and B is brought about coercion, the act of beating, because there is a act of beating, right? So A and B is brought about coercion. This agreement is a coercion and it becomes the old. Okay, because A is beating B for the signing the agreement. Because of that beat, the B is going to sign. That is the by force, right? So it's a coercion. Okay, this is about the meaning, essential element, and for one example about the coercion. We'll see some other parts in the next class. Thank you.